So up until now, in the first 3 modules, I showed you the system, how you can outreach, how you create an army of people to help bring you business, how to use this to build attorney partnerships. Now I want to show you 3 actual cases, 3 actual probate cases I worked on using probate advances, how they create great value for my customer, how they created opportunities for me to list and sell property, and ultimately, in some cases, created great relationships that led to future business as well. So we're going to talk about the first case is a squatter eviction, and that's a common case where a heir has a property, maybe they're out of state, they're modest, parents died, left them the house, and the squatter there, and they don't have the money for the fees and the attorney, and maybe $5,000 to get an eviction attorney who can do the job properly. I'm not talking about the simple filing of papers. I'm talking about somebody's going to go serve them, try to talk to them, try to arrange the cash for keys and such. That's going to cost about $5,000 minimum. And we use probate advances to do that. A second case is partition action, where there's 2 parties and you have to file, get another attorney besides a probate attorney typically to both threaten the partition action and create a filing. And again, it costs anywhere from $2,000, $3,000, $5,000. But that can help move the process along rather than selling half interest in a property at a discount. We'll talk about that in detail. And third is the shotgun rider, what I called it, where it was somebody who didn't really need another attorney. A case was filed and they were an heir, but they were feuding with their sibling. And to give them peace of mind, they needed money to hire an attorney who would ride shotgun on the probate with the other attorney to make sure things happen. So let's talk about that. First case is the squat, and those are the 3 cases we're going to talk about: squatter eviction, partition action, and the shotgun rider. Okay, case 1, squatter eviction. This was in Los Angeles County, but it was actually in the city of Carson in 2023. And the heir was he actually was a decorated war hero. I mean, he had boxes with his ribbons and commemorative medals and such. And obviously, and he had a widow, and she had bad health, was in a nursing home, not the kind of home that you go to when you have any money at all. The kind of money that you can only get that's basically for welfare, because she was indigent. Because when she passed, the only money she had was the equity in the house. She couldn't liquidate it because somebody had taken over, kind of a friend of a friend's girlfriend, drug addict, kind of moved in, started squatting, started making a drug den out of it, for all kinds of nefarious characters. The house was a mess, trash, drug pieces everywhere. It was a mess. And the house was worth about $620,000. Now, another agent had offered to sell it for $310,000. She was representing the buyer, who was an investor. Of course, he was going to flip it, bring it back to market, and she get paid for that commission and maybe some of the profit. That was her option when she came to me. And so she's living there. There were motorcycles, there was machine equipment, there was trash, there was collectibles, there was all kinds of stuff in there. This was probably the most complicated takeover property I've ever been involved in. A motorcycle that couldn't get out through the house. We had to remove a wall to get it out. It was crazy. The whole thing was just crazy. And so they were going to dump the house. I think about, as I said in this graph, 460. I thought, I'm not sure if it was 460 or 360, but they were going to dump the house. They were desperate because she was living really in squalor and had no other option. And so what we did was, I found there are eviction attorneys who are like, paper pushers and process servers and such. And they're inexpensive enough, but today in Southern California, it just doesn't work. We have this militant group of squatters that they look at the house as their net worth and their value and their asset. And they want, big money. They want $100,000, $200,000 to get kicked out. In this case, there's a service I use, which is the landlord advocate. And he was able to, because he's also a private investigator, find information about the squatter, found out she was actually arrested. So he was able to serve her, and he was able to talk to her and challenge her and offer her a very modest cash for keys, I think about $3,000. And so we paid $5,000 to him, I think, and $3,000 to her, and got him out. And instead of selling the house on the cheap at $460,000, we got the full retail value. Now, it was a mess. It was a big win for the family. They were thrilled. But it wasn't even just the money. It was a time. This had lingered for 2 years because they didn't want to sell the property when they were being basically blackmailed. And so by getting the eviction service that was the right service for her for that property, we were able to get the problem solved, and then everybody got paid. And by the way, the neighbors loved it because instead of a drug den next door with squalor and with rodents and pests and stuff, they had a nice new house, a nice house got cleaned out and repainted and refreshed, and the family moved in, and it all worked out for everybody. So that's the squatter eviction. This is a very common case. I do these, I would say, fairly regularly, couple, 3 or 4 times a year at least. Now, so take a look at without the advance, you're going to get $460 with legal fees, maybe net $435. With the advance, it was $620, less legal fees and repayment. She took some additional cash for some other personal needs, which was nice. They got $550,000 and an extra $115,000. Now, the repayment on the probate advance is always expensive. It could be like 30% of the money they're getting. So if they get $10,000, they pay back $13,000. It sounds like a lot, but here's a case where that money generated a profit of $115,000, and I ended up with a commission on the advance. I ended up with a commission on the real estate. It all worked out for everybody, and so everybody came out ahead. Yes, it's expensive, but it's also a very powerful tool. The way I try to look at that is, it's like an ICBM. You wouldn't use it. Our military doesn't use it just for people crossing the border, but if you need to send an ICBM to a bad country, that's why we have them. They're very expensive, but they're also very powerful tools. Okay, so that's the squatter. They got legally removed. Case number 2 is the partition action. Now, partition action is a process in California. I'm not giving legal advice here. I'm just giving kind of my business advice on this. Is you have 2 people own a house who can't agree on what to do, and they don't have an agreement. Or maybe they have an agreement, but they don't abide by it, or it's not clear. Most common case is mom and dad pass and left the property equally to siblings, and one's living there and doesn't want to sell because he's living for free, and the other one wants to sell because he's got $500,000 or more tied up in the property that he would love to put in his pocket or use for investments or for income or for whatever they want to use it for. So in this case, the profile of the heir was, he was a waiter in his late 20s or 30s. He was broke. He inherited 50% of this $600,000 property, and he couldn't afford the attorney's fees. He talked to an attorney, couldn't afford the fees to hire the attorney. Either he had put the money in the probate, but they got stuck because the other party objected. And so the hostile heir was a stepmother, and she was renting out the property and not properly accounting for all the money. He was entitled to half the income if there's net income. This is a very common case where one party kind of seizes control initially and is seen as the property manager to the tenant. The tenant is going to get involved, get in trouble. And so they pay out the rent, and the one party keeps it or keeps too much of it or wherever that might be. And so what do we do? Well, we have to try to unbreak the situation. So we connected him with a probate advance. It's about $10,000. We got an attorney who specializes in partition actions. Now, the process is always the same in my experience. 9% of the time, and when I talk to partition attorneys, they agree. I interview them on my podcast when I can find them, which is 9% of the time the process looks like the attorney writes a letter saying you have the right to hold the property. We want to sell it. You can either buy us out at fair market value, or we want to use a court sale process through partition action. And the other party always ignores it because they're always hostile and whatever, bitter. Then they prepare the filing, and they either send the filing to the other party as a threat, and then if that doesn't happen, then they file. And what usually happens is either with the filing or before the filing, with a copy of the filing, or after the filing, the other party folds. Why? 2 reasons why. One, to fight that filing, that petition, they need to go and hire their own attorney. They have to write a check for $5,000 or $10,000 to defend themselves. And if it goes to court, it could be $100,000. And so the reason why the petition attorney who files this is confident is the law in California is that if a petition is forced, the prevailing party gets attorney's fees and costs reimbursed. So in a case like this, the heir that was filing the partition action could claim he was cheated on rents for years and get his attorney's fees reimbursed, and the other party still has to pay their attorney's fees. So my experience is 9% of the time, when somebody explains to the person wrongly trying to avoid the sale, they realize full like a house of cards. And in this case, agreed to list the property, we sold it at fair market value, and it was about $620,000. And the waiter got his half, about $300,000, all because we got him the $10,000 advance. Number 3 is a case, and a lot of attorneys don't like this, but I'm a real estate agent. My job is to satisfy my clients' needs, to bring them value. In this case, the asset, it was a woman who was one of 2 siblings for about $1 million property. And the other party who was named to be the administrator of the estate, and the woman had missed her hearing date. She had not gone and objected. So the part she didn't want, even though Glasses' stepmother, it's really her brother, was named as the administrator, and she was fearful because her brother was a criminal, was not criminal, but acting illegally, drugs and such. She feared, probably rightly, that he was going to keep all the money somehow, try to cheat the probate estate, sell the house, put it in the estate, write a check, and run off with it. And she was broken down over it. It wasn't just like she worried about or concerned about it. This woman who had whatever limited emotional capacity, wrecked by the fear and the importance of this money. She was living in squalor. She was living in a house with like 4 roommates. 2 or 3 of them were male. I can't even imagine what was going on there. She was, strung out on drugs. And so again, do I want to give a drug user $500,000 to use on drugs? No. But in this case, we were able to get her an advance to help her. I'll explain what we did, and some money to move out of there and get some rent, because we knew she was going to get paid within a year. So it was reasonable to get advance to help her get kind of her life started again. And what happened was I went to an attorney that I knew. I said, look, this is unusual. This woman should have been an objector, but she didn't object in time. And so now the probate's underway. We want you just to ride shotgun and make sure the other attorney does everything correctly, make sure we protect the money. And then I want you to give an update to the client every month. And I have learned, having done this a few times, the attorneys don't really want to do that. But I say, this is what I want you to get paid for. You need to tell us what the cost would be to do that. And so she put together a package, I think it was about $5,000 cost for the attorney's fees for her just to read the documents, be available for the hearings online, and make sure that our client was seen, her needs were met, her distribution was received, and she did. And I remember when she received this money, my client called me, thanked me so much, not just for helping protect her money, but along the way, she felt so much more comfortable, was able to relax in knowing that she was going to get her result. And I think this, the thing that I want to say is the peace of mind was part of her return on investment. And the attorney initially was very against it. I said, listen, you or I could deal with this stress for a year or two. She can't. She just is emotionally wrecked, and she has the money to do it, and that gives her peace. And I think often I look at this and say, well, for $500,000, the $10,000 advance that she got, or maybe she got more for other things, but for the purpose of the legal fees, that's not even $500,000 in this case. $10,000 represents 2% of the money. That's like an insurance policy. That's like a fee that a venture capitalist charges their clients, or a leverage fund charges their clients. It's money spent to guarantee the result she wanted, and she felt great about it along the way. So at the end of the day, she got the advance and legal fees. It's kind of like an insurance premium for her. She got some extra money for her own personal needs, and it all worked out to everybody's benefit. So here's the pattern that we have over and over again, which is that heir has some sort of crisis. It could be a squatter, it could be a hostile co-heir, a fiduciary risk, and they don't have any money. And because they don't have money, they're being bullied by the other party, whether it be the heir who's living in the property, or a squatter, or the other heir who owns the other half of the property. In my experience, when I watch this, they're always bullying the other people. The brother who's administering and not giving information, they're being bullied. And so it gives the weaker party a chance to hire an attorney who's strong enough to represent their interests. We provide the advance. We got a specialist attorney who does this kind of work only. And we get rapid resolution to get the job done and get the customer what they want. So the real win, obviously, is for the customer. The commission is the byproduct. The real win is helping your customer. And because we help our customer, we get paid our commission. And because we get paid our commission, if we do a probate advance, we also get commission on that. But the real win is having the happy customers. So what I recommend you do is pull your probate leads for the week, make an offer, call 10 people who are in probate, see if they're stuck in the mud, need help for attorney's fees or for reimbursement or for other expenses. Try to meet with 3 local wholesalers or investors and introduce the concept of gator lending. And then as far as a partner with an attorney, try to set up a coffee or a lunch meeting with them and see if you can't move your business forward as a result of that. That wraps up our module 4.